We head now to Jackson, Michigan, to the Fourth Circuit Court. A personal protection violation hearing is on against this man, Jacob Larson. The defendant's accused of sending unwanted advances through Facebook messages to this woman seated here, a former high school acquaintance. This incident's a violation of a restraining order against Jacob.
All those messages were like, a lot of them were like last year.
Let me ask you, how many of them were after, I'm asking her, how many of them were after the date of the PPO? 22.
I don't post on that much.
What's that?
I don't post on that much.
This is the second time the judge has questioned the defendant about his contact with the plaintiff. In fact, the same judge had issued the defendant's original PPO 4 months earlier.
I know, but it's like this fatal attraction kind of stuff that I warned you about last time. I told you to just leave her alone. She was a classmate of yours. She apparently has no interest in seeing
I want her to tell me to leave her alone.
You know what? I told you to leave her alone. And apparently that didn't get through loud and clear. So today, you're going to jail for 3 days. And the next time you violate it, you're going to jail for...
You and her are all...
You know what? You got a bad attitude. You had a bad attitude last time you were in court. Okay?
You and her are buddy-buddy. Y'all get along. Y'all are...
45 days county jail. Okay? 93 days in the county jail. You want to go for a year? Try it right now. One more word on you, it'll be a year of county.
Over Facebook. Really?
Over violations of my PPO and your conduct in the courtroom. 93 days in count.
The judge, clearly agitated by the defiant defendant, is sending him to jail.
I ain't never threatened
Stand up. Cuff him. Stand up. Yeah.
Buddy.
Stand up. You're going to jail for a year in the county. 365 days county jail.
Can't do that.
Appeal it.
I will.
Good.
Put your hands behind your back
Tell
now.
me to leave you alone. Tell me to leave you alone. Tell me right now.
Put your hands behind your back. Put your hands behind your back.
Tase his ass right now.
The judge now steps in to help subdue the defendant.
Put it down. That's enough for you. All right? We'll make it 93. You can think about it. All right?
Over Facebook. You know her.
Well, so I know her.
That's not
In the
fair.
community. Get to know you all too much.
I'm a good person. That's all right.
93 days.
Really?
Larson sentenced to 93 days in county jail.
Can't tell me to leave you alone. Can't tell me to leave you alone.
Now to the Moore Justice Center in Brevard County, Florida,
2 charges, assault and resisting. You have the public, Mr.
where public defender Andrew Weinstock and his client are appearing before Judge John Murphy, whose voice you hear.
Public defender, what do you want to do?
Have they filed?
They have.
I'm not waiving.
All right, what do you want to do?
What do you want to do? I'm not waiving. You want to set it for trial, set it for trial.
Judge Murphy wants the defendant to waive his right to a speedy trial because the court's schedule's backed up. Weinstock isn't budging, and tensions are mounting.
If I had a rock, I would throw it at you right now.
You know,
Stop pissing me off. Just sit down. I'll take care of it. I don't need your help.
No,
Sit
you know
down.
what? I'm the public defender. I have a right to be here, and I have a right to stand
I said
and represent
sit
my
down.
clients.
If you want to fight, let's go out back and I'll just beat
Let's go
your
out
ass.
They both head to the hallway behind the courtroom, just out of the view of the court's cameras. Believe it or not, they get into a physical altercation until Judge Murphy returns to the courtroom alone.
Thank you.
I will catch my breath eventually. Man, I'm an old man.
Once Judge Murphy catches his breath, he continues with the rest of the hearings without Weinstock present.
Your choices, considering there's probably going to be a changeover in personnel, are setting it for trial June 9th Or if you were wanting to waive speedy, we would set it for July 15th.
I would like to get it done as fast as possible.
That doesn't help me.
The incident's investigated by the Florida Judicial Qualifications Commission, who charged Judge John Murphy with threatening to commit violence against an assistant public defender, engaging in a physical altercation with counsel, and resuming his docket while defendants were without counsel. The case eventually reaches the Florida Supreme Court, which orders the immediate suspension and permanent removal of Judge Murphy from his post. Andrew Weinstock later resigns from the public defender's office. Next, we're in Placerville, California, for the arraignment of 39-year-old Asher Edwards.
Hello, Judge.
Good afternoon, sir.
Edwards' demeanor may seem pleasant, but just a few days earlier, his alleged behavior was anything but. He was charged with making terrorist threats, assault with a deadly weapon, and obstructing peace officers after a domestic disturbance escalated into a 2-day police standoff.
Mr. Edwards, this is the time and place set for your arraignment. Do you consent to have an arraignment by video conference?
Sir, is this an Maritime Admiralty Law courtroom that we're processing me through?
No, it's not.
Edwards considers himself a sovereign citizen who lives as a free man, as they like to say, under common law as established by the Founding Fathers. Maritime Admiralty law that he's referencing is the law of the sea and international commerce, a body of law that sovereign citizens believe to be the foundation of the country's modern legal system, which they reject.
This is not a Maritime Admiralty Law courtroom. I believe so.
No.
Absolutely, it is. All courtrooms in this country are Maritime Admiralty Law courtrooms that process people, aren't they?
No, sir.
That's false information. Well, either way, this courtroom is trying to process me as state property. You see this fictitious name statement? Asher Edwards, spelled in all capital letters? This is not my name.
Edwards is referring to another sovereign belief that beginning at birth, one is issued a government identity, meaning one's name is spelled in all capital letters, such as on a birth certificate or social security card, and that doesn't represent one's true or free self.
This name was issued to me without my consent, and you cannot legally process me through this courtroom with this without this name in all capital letters that was issued without my consent. My name is spelled Asher Edwards, first capital, all lowercase, Edwards, first capital, all lowercase, and this is the birth name given to me by my parents, protected by the Constitution of the United States.
Even as Edwards grows louder and more animated, the judge appears to take it all in stride and even allows the defendant to finish his rant.
Therefore, it is illegal for you to process me through this courtroom, so you guys have to figure out something else to do with it.
But this judge is all business, so figuring out something else to do with Edwards is not in his plans.
Court will enter a not guilty plea on your behalf. Will show time is not waived. We'll set this matter for pre-preliminary hearing within the statutory period.
And I would like to see the gun. It said I had a gun. I've never had a gun.
As Edwards continues his rant about the alleged gun, the judge reaches for his own weapon of choice, the mute button.
They're lying.
Do not speak while I am speaking, sir.
Edwards continues to plead his case, but to no avail.
Court will set bail in the amount of $72,500. Next matter.
Asher Edwards would later be found guilty of all the charges and sentenced to 1 year in prison. Next, we go to a hearing in Breckinridge County, Kentucky, where the defendant is not typically the one standing before the judge. The accused is Todd Pate, the former sheriff of Breckinridge County. He's charged with assault, operating under the influence, his second offense, criminal mischief, and leaving the scene of an accident. Today, the 51-year-old's in court to change his plea from not guilty to guilty, a decision he's already agreed to in writing. This will allow him to serve just 75 days in jail versus a possible sentence of up to 15 years if he went to trial and was found guilty of all charges. To make it official, all he has to do is say the words to Judge Janet Crocker.
At this time, is it your desire to change your plea from not guilty to guilty?
Do I have to answer that yes or no, or can I make somewhat of a statement?
That is a yes or no answer, sir.
Will I have the opportunity to say anything further?
If it is your intention to change your plea from not guilty to guilty, certainly you'll have an opportunity to make any statement. But if it is not your intent to enter a guilty plea at this time, then I'm going to set your case for jury trial, and you're going to stop wasting my time and everybody else's time this afternoon.
Ma'am, I'm not trying to waste your time.
And then is it your intention to enter a guilty plea at this time or not, sir?
No. Why am I wasting your time,
Mr. Chambers?
The judge ignores the question and checks in with the prosecution.
Why am I wasting your time,
Mr. Chambers, what is the Commonwealth's position at this time, sir?
Your Honor, we would move to revoke the defendant's bond at this time.
The judge orders a brief recess, perhaps hoping Pate's attorney can remind him he's already agreed to plead guilty. Back in court, the judge tries again.
Let's get back on the record and see if we can sort this out. At this point in time, what is Mr. Pate's decision with respect to his guilty pleas?
So I believe I'll just let him answer that question if it pleases the court.
All right. So, Mr. Pate?
Can I say a few things, or?
I need to understand what it is that we're doing here today, Mr. Pate.
Yes, I had every intention of coming in here today and entering a guilty plea. It's difficult for me to enter a guilty plea for a lot of reasons, and I don't want this court to think that I am trying to minimize any responsibility that I had in this situation that occurred.
The problem is Pate doesn't agree with the assault charge and believes the prosecutor only added it because of Pate's position as sheriff and because Pate rejected an earlier plea deal.
I feel like I'm being very much bullied into doing something that's not right. And I want this court to know that Todd Pate holds himself responsible for everything that he did. It's hard for me to lay down and plead to felony charges that don't apply.
By this point, the judge has heard enough.
Is it your intention today to enter this guilty plea?
And if I could address...
This is either a yes or no. Are you going to enter your plea or not?
I guess everybody thinks it's funny. Let me just plea and get it over with for everybody. Plea to something that I absolutely do not feel good about, but I don't want you to try to send me to the penitentiary for years and years. If you can sleep with it, I can sleep with it.
Pate's attorney looks frustrated, while the judge is fed up with Pate's flip-flopping.
I think we're done. At this point in time, I think we're done. Where I think we are today is that on the one hand, the Commonwealth can enforce the terms of this agreement based on the execution. Mr. Pate, I'm talking at this point in time.
Okay, I'm sorry. I'm sorry.
At this point in time, I'm going to sustain the Commonwealth's motion to revoke his bond. He will be taken into the custody and housed in the Breckinridge County Jail.
Your Honor, if I may speak to Mr. Chambers' motion to revoke the bond.
I've already ruled. I've already ruled at this point in time. We're done at this point in time. He's going into jail today.
Pate eventually pled guilty and accepted the terms of his sentence. 75 days in a county jail with credit for time served.